Good day, everyone. I am Sai, and today I am reporting about law and judiciary. The three branches of the government are, of course, important. They exist for the betterment of the country as well as for the people, therefore, they hold the same value. Right. However, as I took a dive deeper into the topic, I see it or saw it as the superhero branch. Why, you ask? The judicial branch directly serves the people by ensuring that order is maintained in our nation, and it answers to the daily struggles of the people of the country. As you all know, diversity is abundant in our country. Like the famous Filipino dessert, we are halo-halo. But despite being mixed, no such conflicts nor chaos has surfaced. And it is all because of the power of the judiciary. Whether the engagement is over law, ideas, politics, or social values which can inevitably clash, they are given peaceful, sensible, and fair resolutions. In addition, this branch makes sure that those conflicts would not overwhelm the civil society. The judiciary is the third organ of the government. It has the responsibility to apply the laws to specific cases and settle all disputes. The real meaning of law is what the judges decide during the course of giving their judgment in various cases. From the citizen's point of view, the judiciary is the most important organ of the government because it acts as their protector against the possible excesses of legislative and executive organs. Rule of the judiciary is the guardian protector of the Constitution and the fundamental rights of the people makes it more respectable than the other two organs. Haywood, in his book, also defines the judicial branch of the government as the branch of the government that is empowered to decide legal disputes. One may ask, how are disputes solved? Is it directly settled in courts? Whether you are involved in a family or neighborhood dispute or a lawsuit involving thousands of dollars or pesos, these processes should be considered. They are often the more appropriate methods of dispute resolution and can result in a fair, just, reasonable answer for both of you and the other party. Settlement and compromise have long been favored in the legal system. In fact, most cases that are filed in a court do settle. So these are the following processes describe ways to resolve disputes. First, negotiation. It is the most basic means of settling differences. It is back and forth communication between the parties of the conflict with the goal of trying to find a solution. The process of negotiation. You may negotiate directly with the other person, or you may hire an attorney to negotiate directly with the other side on your behalf. There are no specific procedures to follow, you can determine your own, but it works best if all parties agree to remain calm and not talk at the same time. Depending on your situation, you can negotiate in the boardroom of a big company, in an office, or even in your own living room. Negotiation allows you to participate directly in decisions that affect you. In the most successful negotiations, the needs of both parties are considered. A negotiated agreement can become a contract and be enforceable. When and how negotiation is used. Most people negotiate every day. In some circumstances, you may want the help of a lawyer to help you negotiate a fair deal. Negotiation is the first method of choice for problem solving and trying to reach a mutually acceptable agreement. If no agreement is reached, you may pursue any of the other options suggested here. This process can be appropriately used at any stage of the conflict before a lawsuit is filed, while a lawsuit is in progress, at the conclusion of a trial, even before or after an appeal is filed. The characteristics of negotiation. First, it is voluntary, it is private and confidential, quick it is very inexpensive, informal and unstructured. Parties control the process, make their own decisions, and reach their own agreements. No third party decision maker. Negotiated agreements can be enforceable, can result in a win win solution. However, negotiations can sometimes be ineffective. That is why, when it fails, disputes are moved to mediation. Mediation is a voluntary process in which an impartial person, the mediator, helps with communication and promotes reconciliation between the parties, which will allow them to reach a mutually acceptable agreement. Mediation often is the next step if negotiation proves unsuccessful. The process. The mediator manages the process and helps facilitate negotiation between the parties. A mediator does not make a decision nor force an agreement. The parties directly participate and are responsible for negotiating their own settlement or agreement. At the beginning of the mediation session, the mediator will describe the process and the ground rules. The parties or their attorneys have an opportunity to explain their view of the dispute. Mediation helps each side better understand the other's point of view. Sometimes the mediator will meet separately with each side. Separate caucusing can help address emotional and factual issues as well as allow time for receiving legal advice from your attorney. Mediations are generally held in the office of the mediator or agreed location. Agreements can be creative. You could reach a solution that might not be available from a court of law. For example, if you owe someone money but don't have the cash, rather than be sued and get a judgment against you, settlement options could include trading something you have for something the other wants. If an agreement is reached, it will generally be reduced to writing. Most people uphold a mediated agreement because they were a part of making it. It can become a contract and be enforceable. If there is no agreement, you have not lost any of your rights and you can pursue other options such as arbitration or going to trial. When and how mediation is used. When you and the other person are unable to negotiate a resolution to your dispute by yourselves, you may seek the assistance of a mediator who will help you and the other party explore ways of resolving your differences. You may choose to go mediation with or without a lawyer depending upon the type of problem you have. You may always consult with an attorney prior to finalizing an agreement to be sure that you have made fully informed decision and that all your rights are protected. Sometimes mediators will suggest that you do this. Mediation can be used in most conflicts ranging from disputes between consumers and merchants, landlords and tenants, employers and employees, family members in such areas as divorce, child custody and visitation rights, elder care, and probate, as well as simple or complex business disputes or personal injury matters. Mediation can also be used at any stage of the conflict, such as facilitating settlements of a pending lawsuit. Attorneys and other professionals provide private mediation for a fee. If you have an attorney, you can work together to select a mediator of your choice. You may want a mediator who is knowledgeable about the subject matter of your dispute. You may wish to use a for-free mediator in the first instance of if early settlement mediation has not resulted in a resolution of your dispute. You may also find mediators or mediation services listed in the telephone directory or available on lists provided by some courts or private professional organizations. When selecting a mediator, you should always check their credentials and get references. Mediators qualified under the District Court Mediation Act or certified pursuant to the Dispute Resolution Act meet statutory standards of training and experience. Who provides this service? Public mediation services are available through early settlement regional centers located statewide. A list of the regional centers can be found online. This program provides the services of volunteer mediators, trained and certified to mediate in the administrative office of the Supreme Court. Mediators in the system are assigned to mediate your dispute by the various program administrators. They are available at minimal or no charge to help you resolve conflicts, often without the assistance of an attorney or the need to go to the court. Characteristics of mediation: promotes communication and cooperation, provides a basis for you to resolve disputes on your own, voluntary, informal, flexible, private, and confidential, avoiding public disclosure of personal or business problems, can reduce hostility and preserve ongoing relationships, allows you to avoid the uncertainty, time, cost, and stress of going to trial, allows you to make mutually acceptable agreements tailored to meet your needs, can result in a win-win solution. The third method of resolving dispute is arbitration. It is the submission of a disputed matter to an impartial person, which is called the arbitrator, for a decision. The process of arbitration, it is typically an out-of-court method for resolving dispute. In a more formal setting, the arbitrator will conduct a hearing where all of the parties present evidences through documents, exhibits, and testimony. The parties may agree to, in some instances, establish their own procedure, or an administrating organizations may provide procedures. There can be either one arbitrator or a panel of three arbitrators. An hearing is usually held in offices or other meeting rooms. How and when arbitration is used. A common use of arbitration is in the area of labor disputes between fighters, and the city in wage disputes, for example. You will usually be represented by an attorney in arbitration. Many contracts have clauses which require that disputes arising out of that contract be arbitrated. You may have seen such a provision when you applied for a credit card or opened a retirement account or other account with a stockbroker. You may want to explore using this process if you on the other side agree that the problem needs to have someone make a decision, but you do not want the expense of going through the court process. If you agree to arbitrate or sign a contract with an arbitration clause, you should understand that the arbitrator may make the final decision and that you may be waiving your right to a trial in court. Who provides this service? Many attorneys, other professionals, or professional associations offer their services as arbitrators. Typically, your attorney will select the arbitrator based upon the particular type of the dispute. In complex and highly technical cases, often an arbitrator who is knowledgeable in that field is chosen. Usually, fees are charged. Some courts offer court-sponsored, non-binding arbitration and have specific procedural rules to follow. The characteristics of arbitration: can be used voluntarily, private, may be less formal and structured than going to court depending on applicable arbitration rules, usually quicker and less expensive than going to court depending on applicable arbitration rules. Each party will have the opportunity to present evidence and make arguments, may have a right to choose an arbitrator with specialized expertise. A decision will be made by the arbitrator, which may resolve the dispute and be final. Arbitrator's award can be enforced in a court. If non-binding, you still have the right to a trial. The fourth and the last method of resolving disputes is litigation, or going to court. It is the use of the courts and civil justice system to resolve legal controversies. Litigation can be used to compel opposing party to participate in the solution. The process. Litigation is begun by filing a lawsuit in a court. Specific rules of procedure, discovery, and presentation of evidence must be followed. The attorney for the other side will want to take your deposition to learn more about the facts as you see them and your position in the case. There can be a number of court appearances by you and or your lawyer. If the parties cannot agree how to settle the case, either the judge or jury will decide the dispute for you through a trial. A trial is a formal judicial proceeding allowing full examination and determination of the issues between the parties, with each side presenting its case to either a jury or a judge. The decision is made by applying the facts of the case to the applicable law. That verdict or decision can conclude the litigation process and be enforceable. However, if appropriate, the loser can appeal the decision to a higher court. In some cases, the losing party may have to pay the cost of the lawsuit and may have to pay the other party's attorney fees. How and when litigation is used. American civil justice system is one of the best in the world. The Constitution of the United States gives the right to a fair trial. If you want your day in court with a judge or jury of your peers deciding the outcome, then the pursuit of litigation and trial of the case is for you. If you cannot settle your differences through negotiation, mediation, arbitration, or some other means, then you should pursue litigation through the courts with your lawyer. Characteristics of litigation: involuntary, formal and structured rules of evidence and procedure. Each party has the opportunity to present its evidence and arguments and cross examine the other side. Public, court proceedings and records are open. The decision is based on the law. The decision can be final and binding. Right of appeal exists. Losing party may pay cost. Now that we have discussed the methods, let us now move on to the machinery of the judiciary. How does it function? Number 1, impartiality. It will be impossible for the judiciary to do justice in a state if it is not impartial. Impartiality is a key characteristic of the judiciary because every function of the judiciary requires it. The judicial organ of government must be a neutral body that is not in support of any body in their judgment. This way, it will be able to give judgment without fear or favor. Number 2, political neutrality. The impartial of neutral feature of the judiciary must also cover its political affairs in the nation. Members of the judiciary must not be affiliated to any political group. They must not take part in partisan politics. The reason is because a member of the judiciary can be influenced because of the fact that he or she belongs to a political party. Thus, there is most likely not going to be neutrality in political matters in the country. Number 3, permanent. Another indispensable characteristics of the judiciary that helps it to perform its functions without fear or favor is permanence. This means that judicial officers are not to be removed from their offices until they reach their retirement age. The judiciary is a permanent institution inherited by successive government. It does not change along with the government. Fourth is independence. The judiciary is not supposed to be attached to the executive and the legislature because they are the last hope of the common man. The rationale behind this is the fact that the judiciary will not be able to perform its functions if it is dependent on either the executive or the legislative organ of the government. By making the judiciary independent, it is very easy for them to say the truth and give correct judgment without the fear of being sacked from the office or decrease in salary. The fifth one, professionalism. The judicial is made up of those who are legal experts. Every member of the judiciary must have received adequate training in law. In Nigeria, a lawyer must have studied for 7 years before he or she can be accepted as a legal officer into the Nigerian legal system. In other countries of the world, there's also requirements like this. The reason is because law is a very important aspect of every society and it must be handled by people who really understand it. Stable tenure of office of judges. Number 6. This is similar to the feature of permanence. It simply means that the number of years the members of the judiciary are going to stay in the office must be stable. 7 is judicial immunity. Judges enjoy protection in the performance of their duties. The pronouncement of the judge are not taken against while delivering judgment. Number 8, due process. The judiciary operates according to laid down rules and precedents. Number 9, code of conduct. The judiciary has prescribed a code of conduct. They have ways of behavior, thus, if a lawyer or judge goes contrary to the stipulated code of conduct, he will be punished duly by the law. In Nigeria, the behavior of lawyers is governed by the Rule of Professional Conduct, or RPC. The chief quality which helps the judiciary to faithfully administer justice and to perform its function efficiently is judicial independence. It is only when the judiciary works independently without any interference of the other two organs of the government that it can carry out its high responsibilities. The independence of judiciary, writes Dr. P. Sharan, is a cornerstone of every democratic government, and upon it is built the structure of civil liberty. Judiciary can perform its function only when it is free to administer justice according to law. Without being well organized and independent, it can never serve its purpose. Therefore, judiciary must be organized in such a way as can enable the judges to give their judgments without any fear or favor. What I will highlight in my report about the third branch of the government is the Philippine judiciary. Under Article 8, the 1987 Philippine Constitution, the judicial power shall be vested in one Supreme Court and in such lower courts as may be provided by law. This power includes the duty to settle actual controversies involving rights that are legally demandable and enforceable, and to determine if any branch or instrumentality of government has acted with grave abuse of discretion amounting to lack of exist of jurisdiction. The Philippine legal system is a mixture of customary usage, Roman civil law and Anglo-American common law systems, and Islamic law. The legal system is the result of the immigration of Muslim Malays in the 14th century and the subsequent colonization of the islands by Spain and the United States. The civil law operates in areas such as family relations, property succession, contract, and criminal law, while statutes and principles of common law origin are evident in such areas as constitutional law, procedure, corporation law, taxation and insurance, labor relations, banking, and currency. Administration of justice involving the settlement of disputes and the punishment of crime is and always has been a vital function of government. In fact, it might well be said to be the basis of all orderly government. The experiment in government, which was begun by the American people when they separated themselves from the domination of England, reached a new stage in its development when Admiral Dewey was victorious in Manila Bay on May 1st, 1898. It is perhaps impossible to determine at this time whether the new stage is the result in an attempt at colonization or in the establishment of a new nation. From the point of view of the student of the comparative history of law and institutions, it matters little what the years may produce. It is rather more pertinent to inquire concerning the nature of the acquisition and the developments which have been made. In a small compass, it is impossible fully to discuss the administration of justice in the Philippine Islands. Historically and comparatively, it is possible only to give a bird's eye view of the development of this institution, approaching the subject in detail only at the more interesting and important stages. So now let us go back to the historical developments of the Philippine judiciary. First, judicial system prior to the Spanish conquest. Filipinos had their own laws and system of administering justice. The government was patriarchal in form. The unit of government was the barangay, a settlement of about 30 to 100 families. Oral and written laws existed in ancient Philippines. The unwritten laws were the customs and traditions which were handed down by tradition from generation to generation. The written laws were promulgated by the datus. If all ancient written laws of the Filipinos were lost with the exception of the Code of Maragtas and the Code of Calantiao, both from Panay Island. Number 2, judicial system during the Spanish regime. The Philippine courts during the Spanish sovereignty consisted of superior courts, Audiencia Territorial de Manila, the Audiencia de lo Criminal de Cebu, and the Audiencia de lo Criminal de Vigan. The inferior or local courts were the courts of first instance and justice of the peace courts, both constituting the base of the Spanish judicature in the Philippines. The first Audiencia Real was created in Manila in order to check the powers of the Governor General. The Audiencia was an appellate court. Appeals are made here from sentences of judges of first instance. For 300 years, the Audiencia exercised its functions. The Audiencia de lo Criminal of Vigan had Luzon and the Batanes Island, and the Audiencia de lo Criminal de Cebu had Visayas and the northern part of Mindanao had only criminal jurisdiction. The courts of first instance were established in the provinces under the alcaldes mayor that were deprived of their executive functions. These courts were divided into three classes: the entrada, the ascenso, and the termino. An institution known as residencia was established to check on the powers of the Governor General and other officials. Number 3. Judicial system during the American regime. The Philippine Commission enacted Act Number 136, which abolished the Audiencia or Supreme Court and courts of first instance. It replaced a new system modeled under the judicial system of the United States. It provided that courts of justice shall be maintained in every province in the Philippines, and judicial powers of the government of the Philippines shall be vested in a Supreme Court, courts of first instance, and justice of the peace. The Philippine Bill of 1902 and the Jones Law of 1916 ratified the jurisdiction of the courts vested by the Act Number 136. Act 136 established the Supreme Court, consisted of one Chief of Justice and 6 associate judges. There was one CFI in each province group to form a judicial district. There were 4 more additional judges called judges at large, 2 Americans, 2 Filipinos, without territorial jurisdiction of their own. The Secretary of Finance or the Secretary of Justice could assign any of them to any district. They assisted in clearing dockets where 3 a judge could not sufficiently cope with the volume of work. The justice of the peace was important because of their accessibility to the masses. The Supreme Court of the United States had jurisdiction to review, revise, reverse, modify, or affirm the final judgment and decrees of the Supreme Court of the Philippine Islands in all actions and proceedings in which the Constitution or any statute, treaty, title, right, or privilege of the United States was involved, or in which the value in controversy exceeded $25,000. One notary public was required for each municipality who was appointed by the judge of the first instance of the province. Private defenders and private counsels were provided to the accused. Courts were allowed to employ assessors to assist in trials and to advise judges. The fourth judicial system during the Commonwealth. The Constitutional Convention adopted the Philippine Constitution that was signed by President Roosevelt and ratified by the Filipino people at a plebiscite It took effect on November 15, 1935, upon inauguration of the Commonwealth of the Philippines. It became the constitution of the present republic upon its inauguration on July 4, 1946. The Philippine Constitution provided for the independence of the judiciary, the security of tenure of its members, prohibition on diminution of compensation during their term of office, and the impeachment method of removal for justices. Judicial system during the war and its aftermath. The Imperial Japanese forces occupied the city of Manila and proclaimed the military administration under martial law over the territory occupied by the army. Courts remained in existence with no substantial change in their organization and jurisdiction, provided that their outlines be approved by the Commander in Chief of the Imperial Japanese Forces. Commonwealth Act Number 2682 created the People's Court, composed of a presiding judge and 14 associate judges who were appointed by the President with the consent of the Commission on Appointments. The Office of the Special Prosecutor took charge of the direction and control of the prosecution of cases cognizable by the People's Court. Preliminary examination and investigation was not required. The People's Court and the Office of the Special Prosecution were under the supervision and control of the Department of Justice. Throughout the period since liberation, the Supreme Court has maintained and strengthened its prestige. Faced by difficult decisions during the Japanese occupation, the court has won respect for legal consistency and impartiality. The court as they exist today have passed beyond the experimental stage, and the results obtained fully justify the wisdom of the men who planned and established them. From the beginning, Filipino lawyers of high reputation have shared in the development, and they deserve great praise for the present success. The Chief Justice and the two of the six associate justices of the Supreme Court, 22 of the 36 judges of the courts of first instance, the Secretary of Finance and Justice, the Attorney General, and 9 of his 13 assistants, and 3 of the 5 members of the Code Committee are Filipinos. The best summary of the results attained by the new courts is found in a statement by Commissioner Henry C. Ide. In his report to the Commission dated November 6, 1903, justice is administered evenly, uniformly, honestly, expeditiously, and ably throughout the islands. The American government has, by establishing a just and stable system of courts, hastened the day for Filipino independence. We have a lot of different laws created for different purposes. We have the contract law, liability law, family law in terms of divorces, custody of children, and so forth. Plenty amount of criminal laws too. There are even laws about the responsibility of public officials. Law has been defined as a body of rules of action or conduct prescribed by a controlling authority and having binding legal force. That which must be obeyed and followed by citizens subject to sanctions or legal consequence is a law. Although intended to protect the fundamental rights and liberties of citizens, the legal systems and its laws are not always readily understood by the average citizen. At what point do we cross that fine line between legal and illegal? And on what basis is that line even drawn in the first place? Most people understand and accept laws prohibiting acts of murder, thievery, physical harm, and financial malfeasance. But there are plenty of other laws that might give us pause. For example, in Minnesota, United States, any game in which participants attempt to capture a grease or oil pig is illegal. The same laws also prohibits turkey scrambles. Don't attempt to substitute a ferret for a hunting dog in West Virginia. Anyone who hunts, catches, takes, kills, injures, or pursues a wild animal or bird with a ferret will face a fine of no less than $100 but no more than $500, and no fewer than 10 but no more than 100 days in jail. While you may never have considered taking part in a turkey scramble or hunting with a ferret, chances are good that you have broken some laws at some time. Perhaps even in the last 24 hours, did you exceed a speed limit while driving? Roll through a stop sign at an empty intersection while riding your bike? Drive to the mini mart without wearing your seatbelt? Although unlikely that you will be prosecuted and jailed for these minor traffic offenses, the fact that you broke the law, why do we have so many laws? One may ask. Let's take a closer look at the rule of law and in society and why laws are created in the first place. Law defined. It is a distinctive form of social control backed by the means of enforcement. It defines what may and what may not be done, a set of public and enforceable rules that apply throughout a political community. Law is usually recognized as binding. Now let us look at law over the ages. Where did laws originated? First, let's discuss the Code of Hammurabi, one of the earliest and most complete written legal codes and was proclaimed by the Babylonian king Hammurabi, who reigned from 1792 to 1750 BC. Hammurabi expanded the city-state of Babylon along the Euphrates River to unite all of southern Mesopotamia. The Hammurabi Code of Laws, a collection of 282 rules, established standards for commercial interactions and set fines and punishment to meet the requirements of justice. Hammurabi's code was carved into a massive finger-shaped black stone stele or pillar that was looted by invaders and finally rediscovered in 1901. So, who is Hammurabi? Hammurabi was the sixth king in the Babylonian dynasty, which ruled in central Mesopotamia, which is today's Iraq, from 1894 to 1595 BC. His family was descended from the Amorites, a semi-nomadic tribe in western Syria, and his name reflects a mix of cultures. Hamo, which means family in Amorite, combined with Rapi, meaning great in Akkadian, the everyday language of Babylon. In the 38th year of his reign, Hammurabi began to expand his kingdom up and down the Tigris and Euphrates River Valley, overthrowing the kingdoms of Assyria, Larsa, Ishuna, and Mari, until all of Mesopotamia was under his sway. Hammurabi combined his military and political advances with irrigation projects and the construction of fortifications and temples celebrating Babylon's patron deity, Marduk. The Babylon of Hammurabi's era is now buried below the area's groundwater table, and whatever archives it kept are long dissolved, but clay tablets discovered at other ancient sites reveal glimpses of the king's personality and statecraft. One letter records his complaint of being forced to provide dinner attire for ambassadors from Mari just because he'd done the same for some other delegates. Do you imagine you can control my place in the matter of formal wear? That was stated in the letter. So, what is the Code of Hammurabi and its significance? The black stone seal containing the Code of Hammurabi was carved from a single four-ton slab of diorite, a durable but incredibly difficult stone for carving. At its top is a 2.5-foot relief carving of a standing Hammurabi receiving the law, symbolized by a measuring rod and tape, from the seated Shamash, the Babylonian god of justice. The rest of the 7-foot 5-inch monument is covered with columns of chiseled cuneiform script. The text compiled at the end of Hammurabi's reign is less a proclamation of principles than a collection of legal precedents set between prose celebrating Hammurabi's just and pious rule. Hammurabi's code provides some of the earliest examples of the doctrines of lex talionis, or the laws of retribution, sometimes better known as an eye for an eye. You know, the Code of Hammurabi includes many harsh punishments, sometimes demanding the removal of the guilty party's tongue, hands, breast, eye, or ear. But the code is also one of the earliest examples of an accused person being considered innocent until proven guilty. The 282 edicts are all written in F then form, For example, if a man steals an ox, then he must pay back 30 times its value. The edicts range from family law to professional contracts and administrative law, often outlining different standards of justice for the three classes of Babylonian society: the propertied class, freedmen, and slaves. A doctor's fee for curing a severe wound would be 10 silver shekels for a gentleman, 5 shekels for a freedman, and 2 shekels for a slave. Penalties for malpractice followed the same scheme. A doctor who killed a rich patient would have his hands cut off, while only financial restitution was required if the victim was a slave. 300,500 years ago, King Hammurabi of Babylon compiled a series of commands regarding the day-to-day life of his people. These commands, which dealt with topics from divorce to contracts to murder, were preserved on a diorite stela, binding future Babylonian kings to Hammurabi's new code of law. The great difference from nowadays: in the code of Hammurabi, society was divided in three groups: superior men, commoners, and slaves, and further clearly divided into two sexes, and penalties were very different according to status. Nowadays, in theory, everyone is equal before the law. Roman law. As a legal system, Roman law has affected the development of law in most of Western civilization as well as in parts of the East. Roman law was not confined in its genesis to the city of Rome or the Italian peninsula, but to the genius of minds from many lands, and it has left a great legacy in the legal systems of the world. The Emperor Justinian, building on earlier jurists, codified in a structure written from a sophisticated system of law by means of the digest, institutes, and codex. This codified system of law has influenced most of the civil law around the world. The concepts inherent in the legal order comprise in the ius naturale and ius gentium, intended to extend beyond national borders, are today the cornerstones of human rights law and international law throughout the world. The influence of Roman law on the development of the common law is equally undeniable. So now let's discuss a brief background of Roman era, the phases of Roman history. From around 510 BC, the Roman Republic developed as a small city-state. By 272 BC, following a period of territorial expansion, Rome's control over Italy was almost complete. In two wars, Carthage, a rival for the central western Mediterranean, was eventually defeated. Subsequently, Rome was at war with the East. Territorial expansion in the 2nd century BC changed the face of Italy from small farming holdings to large states with slaves labor. Over a period of time, a professional army became mobilized. This enhanced the power of ambitious generals who set a pattern of throwing Rome into a civil wars that contributed to the downfall of the Republic. After much strife, a period of peace and stability commenced, and Octavian, known as Augustus, restored constitutional government, and the empire took shape. Around this time, all the territory surrounding the Mediterranean and territory far beyond the Mediterranean was part of the Roman Empire. By the 1st century AD, the Roman Empire extended from Britain to Dacia, equivalent to modern Romania. However, Rome failed to hold the territory north of the Danube, occupied by the Germanic peoples. In later times, the Germanic peoples were to overthrow the Roman Empire. Okay, so now we are done discussing the history or the origin of law. Let us now move on to the function of law. Its function: protects individual rights and liberties. It helps resolve disputes between individuals and it maintain law and order, or order in general. So, what is the relationship between law and politics? Law has widely been seen as a vital guarantee of public order, but disagreement about the relationship between law and morality, and especially about the extent to which law should uphold individual freedom, have long been core themes in political theory. As far as the position of judges is concerned, although the courts have usually been viewed as strictly separate from politics in practice in many parts of the world, they have acquired a growing capacity to shape public policy. In view of the crucial role that law plays in regulating social behavior, no one can doubt that it has immense political significance. According to Dr. Miro Cirar, the law functions in relation to politics in three basic aspects, namely as a goal. Politics can define certain predominantly legal values or institutions as its goal. In this case, the political understanding of these values or institutions becomes almost identical to an authentic legal understanding of the same values or institutions. A means. Politics can comprehend the law merely as a means for the fulfillment of certain political interests. In this case, politics is neutral in its attitude toward the law. Lastly, an obstacle. Finally, politics can interpret law as an obstacle on the way toward the realization of certain political goals. In this situation, either politics prevails over law or vice versa. In the first case, politics effectuates its solution at the expense of the rule of law, while in the second case, the autonomy of law is preserved through the decisions of the highest courts or by other actions taken by lawyers, intellectual associations, organizations, and the public in order to stop illicit acts of political actors. Law and politics create their own particular pictures of reality. Sometimes those pictures overlap, sometimes they differ. Yet there is something that the law should never include in its sphere, namely the differentiation of adversaries according to a purely political criterion. This leads to a strict separation between ours and yours, or in its most radical expression, to a strict separation between friend and enemy. When the latter occurs, politics inevitably prevails over the law and reduces or damages the autonomy of the rule of law. Certain checks and balances between law and politics are critical for the relatively peaceful and value positive or constructive development of mankind and democratically organized societies. Liberal theories sensitive to civil liberties and human rights tend to emphasize the limited province of law operating simply as a means of guaranteeing orderly existence. A conservative view, however, emphasizes the link between law and social stability, acknowledging that law has an important play in enforcing public morality. Law and politics, separately or together, both encourage and suppress the development of societal relations. While they both also function to bring about justice and order, the essence of their separate and connected but not integral existence is to help set each other's borders. These borders prevent excessive one-sidedness in politics or the law that is similar to checks and balances mechanism. This view of law also has significant implications for the judiciary, whose task is to interpret law and adjudicate between parties to a dispute. Notably, judges must be independent in the sense that they are above or outside the machinery of government and not subject to political influence. The rule of law on human rights. The rule of law definition is a study used in the earliest report as well as that of former UN Secretary General Kofi Annan, who described it as a concept that refers to a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. The UN rule of law definition's linguistic backbone consists of the UN Charter and the four pillars of the modern international legal system: international human rights law, international humanitarian law, international criminal law, and international refugee law. It also includes UN human rights and criminal justice standards developed in the last half century. The 2011 Rule of Law Basin study discussed the different definition of the rule of law, the ensuing debate, and related underlying concepts. The reasons for using this UN definition were expounded in the report. The state is the agency put to task in questions of rule of law. The UN definition, widely used and often linked to state-building efforts, provide a foundation for indicators. How the rule of law matters. No matter who we are or where we live, the rule of law affects us all. It is the foundation for communities of justice, opportunity, and peace, underpinning development, accountable government, and respect for fundamental rights. Research shows that rule of law correlates to higher economic growth, greater peace and less inequality, improved health outcomes, and more education.